In the UK, subscription services have become part of everyday life: streaming platforms, meal kits, fitness apps, cloud storage, beauty boxes, and more. But as subscriptions have grown, so have consumer complaints. Many people report being frustrated by hidden fees, automatic renewals they didn't expect, and subscriptions that are difficult to cancel. The UK government has acknowledged these issues. In response, it introduced major reforms through the Digital Markets, Competition and Consumers Act 2024, known as the DMCC Act. Although the act itself is in force, the subscription-specific rules will not take effect until autumn 2026, following delays announced by the Department for Business and Trade. Today's video breaks down what consumers can expect, what rights already exist, and how the new rules aim to address the problems many people face. Section 1. The scale of the subscription problem. Subscription services have expanded rapidly in the UK. According to government consultation data, there are around 155 million active subscriptions in non-regulated sectors, representing approximately £26 billion per year in consumer spending. The same consultation found that about 5.8% of active subscriptions are unwanted, meaning an estimated 9.7 million subscriptions are being paid for by consumers who no longer want them. The reasons include: lack of clear information at sign-up, free trials that convert into paid plans without sufficient notice, auto-renewals that consumers didn't expect, cancellation processes that are difficult or time-consuming. These issues are not hypothetical, they are documented concerns identified in the government's consultation on subscription contracts. Section 2, Existing consumer protections before 2026. Before the new subscription-specific rules take effect, consumers already have rights under existing UK law, including 1. Consumer Rights Act 2015. This law requires contract terms to be fair, transparent, and prominent. Unclear or hidden auto-renewal terms may be considered unfair. 2. Consumer Contracts, Information, Cancellation and Additional Charges, Regulations 2013. These regulations require businesses to provide clear pre-contract information, details about cancellation rights, a 14-day cooling-off period for most digital and service contracts. 3. Guidance on auto-renewals. Government guidance states that contract terms extending a subscription beyond what a consumer would normally expect may be unfair unless renewal terms are clearly communicated and reasonable reminders are provided. These protections exist today, but enforcement has been inconsistent, and many consumers still fall into subscription traps. This is why the DMCC Act introduces a more structured and enforceable regime. Section 3, the DMCC Act, What Changes in 2026. The Digital Markets, Competition and Consumers Act 2024 introduces a dedicated framework for subscription contracts. However, the subscription-specific rules will not take effect until autumn 2026 at the earliest, due to delays in secondary legislation. Here are the key changes consumers can expect once the rules are implemented. A. Clearer pre-contract information. Businesses will be required to provide standardized, prominent information before a consumer enters a subscription contract, including the price and payment frequency, the contract length, whether the subscription auto-renews, how to cancel, whether a free trial converts into a paid plan. These requirements aim to prevent consumers from being surprised by charges or renewal terms. B. Mandatory renewal reminders. Under the new rules, businesses must send reminders before a free trial converts into a paid subscription, a discounted introductory period ends, a subscription auto-renews. Reminders must include clear information about the renewal terms and how to stop the renewal. C. Easier cancellation processes. One of the most significant changes is the requirement for simple, accessible cancellation mechanisms. The DMCC Act aims to ensure that consumers can cancel online if they signed up online. Cancellation processes are not unnecessarily long or complex. Businesses cannot use excessive retention tactics. The government has identified difficulty exiting a contract as a major consumer harm. The new rules will require businesses to offer a straightforward cancellation route. D. Post-contract information requirements. After sign-up, businesses must provide a confirmation notice, key contract terms, information on how to cancel, details of any upcoming changes. This ensures consumers have a clear record of what they agreed to. E. Cooling off periods for renewals. The new regime introduces a cooling off period after certain renewals, allowing consumers to cancel shortly after a renewal occurs. This applies to free trials converting into paid plans, introductory offers ending, annual subscriptions renewing. The aim is to reduce the financial impact of accidental renewals. F. Enforcement and penalties. The Competition and Markets Authority, CMA, will have enhanced powers to enforce the rules. Under the DMCC Act, the CMA can investigate non-compliance, issue penalties, require businesses to change their practices. Some parts of the DMCC Act are already in force, and the CMA has begun enforcement in related areas, such as banned practices around fake consumer reviews. Section 4, Hidden Fees, what the law says. Hidden fees are a common complaint in subscription services. Under existing law and the upcoming DMCC rules, businesses must disclose all fees clearly before the consumer enters the contract. Avoid presenting essential information in a misleading or obscure way. Ensure that any additional charges are transparent and agreed to. The DMCC Act strengthens these requirements by mandating clear, prominent price transparency, building on existing unfair commercial practices rules. Section 5, Auto Renewals, what consumers need to know. Auto renewals are not banned under UK law, but they must be fair, transparent, properly communicated. Under the DMCC subscription regime, auto renewals must be clearly disclosed before sign-up. Consumers must receive renewal reminders. Businesses must make opting out easy. Consumers may have a cooling-off period after renewal. These measures aim to reduce unintentional renewals. Section 6, Hard-to-cancel subscriptions. The government has identified difficult cancellation processes as a major consumer harm. Examples include requiring customers to call a phone line with limited hours, forcing customers through multiple retention screens, hiding cancellation options deep within account menus. The DMCC Act will require businesses to provide simple, accessible, and proportionate cancellation methods. This aligns with the government's goal of preventing consumers from becoming stuck in subscriptions they no longer want. Section 7, What consumers should do now. Even before the new rules take effect, consumers can protect themselves by 1. Reviewing renewal dates, set reminders for free trials and annual renewals. 2. Checking cancellation policies, look for cancellation instructions in confirmation emails or account settings. 3. Using the 14-day cooling-off period. Most digital subscriptions allow cancellation within 14 days under existing regulations. 4. Challenging unfair terms. If renewal terms were unclear, consumers can raise a complaint under the Consumer Rights Act 2015. 5. Monitoring bank statements. Unwanted subscriptions often go unnoticed for months. Section 8, What businesses should prepare for. Although the subscription rules will not take effect until autumn 2026, businesses should begin preparing now. They will need to adjust their systems to comply with new information requirements, reminder obligations, cancellation process standards, cooling off periods. The DMCC Act will significantly change how subscription services operate in the UK. The subscription economy offers convenience, but it has also created challenges for consumers, especially around hidden fees, auto-renewals, and difficult cancellation processes. The UK's Digital Markets, Competition and Consumers Act 2024 aims to address these issues through a comprehensive subscription contract regime. Although the rules are not expected to take effect until autumn 2026, they represent a major shift toward transparency and fairness in the subscription market. For consumers, this means clearer information, better reminders, and easier cancellation. For businesses, it means adapting to a more regulated environment. As secondary legislation and CMA guidance are finalized, more details will emerge, but the direction is clear. The UK is moving toward stronger consumer protection in the subscription economy.